Agency and creation of agency. An agent is a person employed to do any act for another or to represent another in dealings with the third persons. The person for whom such act is done or who is so represented is called a principal. Any person competent to contract may appoint as a agent. Minor, lunatic, drunken persons are not entitled to act as agents because the act of agent is the act of the principal. So while appointing an agent, the principal should take precautionary measures. If the agent commits any wrong, then the principal is responsible to the third parties. For the creation of agency, the consideration is not necessary. Creation of agency. The agency may be created in any of the following ways: by written document, by the conduct of the parties, by necessity, by subsequent ratification. In by written document, an agency may be created by the principal by executing a written agreement by the agent. If the agency is created through written agreement, then it is useful to solve the future disputes. It is also helps to safeguards the rights and interest of the principal agent and also the third party. Example, general power of attorney should be in written according to the Indian Stamp Act. By the conduct of the parties, the relationship agency may also arise by the conduct of the parties or according to the circumstances. These agencies are called implied agencies. These these are called these are created from the conduct and situational relationship of the parties. An auctioneer has implied authority to sign a contract behalf of both buyer and the seller. The following is one of the way of creation agencies by the conduct of the parties. The doctrine of estoppel or agency by holding out. If a person knowingly accepts an act to act on behalf of and allows him to do so, later on the actual person cannot deny the act of that person if there is any objection regarding this aspect of the actual owner objects the acts of the agent immediately. If he cannot do so, the act become valid under the law of agency. This is otherwise called the doctrine of estoppel or agency by holding out. By necessity. In case of emergency, these type of agencies are created. The following is the example in this regard. Example that the plaintiff sent a certain quantity of butter to a dealer by the defendant railways. Due to strike, the train was stopped in the middle of the way. To avoid further loss, defendant sold the butter and remitted the amount to plaintiff. But the plaintiff sued the defendant for the loss. Finally, court held that the defendant act is come under the purview of agent in necessity and defendant not liable. By subsequent ratification. Ratification means confirmation. In general, if the agent done one act without proper consent from the principal, later on the principal himself accepts the act done by the agent is called ratification. This is one source of creation of agency.